everybody. It's a pleasure to see you all at CPDB this year. And prior to the start of the panel, I want to announce a new initiative of CPDP. We're expanding into Latin America, and we're going to host in June this year a conference, CPDP Latin America. And for a little bit of a further introduction, I'd like to introduce you to Danilo Doneda from IDP and Luca Belli from FGV Brazil, the two people really pushing this initiative forward.
Thank you very much, Dara, and sorry for squatting the beginning of your session. So before you set the academics on fire, we just wanted to announce that actually CPDP is expanding into Latin America. So we will have the pleasure and the honor to organize CPDP LATAM in Rio de Janeiro at the end of June. There is already a website with all the information you need about our call for papers, call for sessions, and our team on cpdp.lat. It will be at FGV, where I work, which is one of the most renowned academic institutions in Brazil, and also ranked as the 6th most influential think tank in the world. We are extremely proud to build this in synergy with Dara and the CPDP team. If you have any questions about what we are going to do and how we are going to organize this, you find a lot of information on the website, but really feel free to reach out either now or in the coffee break, in the lunch break. There is one last thing that I wanted to mention, that actually CPDP LATAM will be not only one event, but actually 3 events in one, as we will have one entire day, the second day dedicated to the Latin American meeting of My Data, and that is an event more for startuppers and innovators, and then a last day that Danilo is directing with the Privacy Law Scholars Conference Latin America, where we will also have, therefore, the possibility to organize and discuss papers in a closed format, not only in the CPDP LATAM classic format, which, of course, will also be very welcome. So thank you very much for your attention, and now, if you want to set the academics on fire, please go ahead.
Great. Good morning, everyone, and thank you all very much for coming along to join us with this panel with what I hope is going to be a little bit of a twist today. And it's a panel that's been organised by the IAPP. My name is Helen Dixon. I'm the Commissioner for Data Protection in Ireland. And I've been given an opportunity today to challenge this group of academics you see on the stage to demonstrate to all of us that they don't just hang out in their ivory towers thinking great thoughts and admiring the same old intractable data protection problems year in, year out. And I'm challenging them today to demonstrate for us that the research that they do and the thinking that they do can lead to real solutions for society, for industry, and solutions that can also help regulators. So I think we've got a very good lineup today in terms of trying to deliver on that aim, and let me introduce you to them very, very briefly. On my very far left, we have Franziska Boehm. Franziska is a leading European privacy law scholar. She's a professor for IP rights at the Karlsruhe Institute of Technology. She's published a range of papers in both English and German languages on what is a very impressive array of critical issues in data protection terms. She's published on data retention, IT security awareness of employees, privacy shield, PNR data, to name just a small subset of her publications. And actually, when I was reviewing your publications, Franziska, it really reminded me simultaneously both of how complex data protection law is, but also how important regulation of it is. So thank you for contributing today. Next to Franziska, we have Neil Richards. Neil is without dispute one of the world's leading experts in privacy law, information law, and freedom of expression. He writes, teaches, and lectures about the regulation of technologies that are powered by human information and revolutionizing our society. Professor Richards holds the Koch Distinguished Professor of Law at Washington University School of Law. His many scholarly and popular writings on privacy and civil liberties appear in a wide variety of media, from the Harvard Law Review, Yale Law Journal, The Guardian, and Wired. And I'm looking forward to his forthcoming book that's due out this year on why privacy matters. Next to Neil then, we have Gabriela r-Fortuna, known to many of you. She's a European privacy law scholar. She obtained her PhD 7 years ago in Romania on the subject of individuals' personal data rights. She worked between 2014 and 2016 for the European Data Protection Supervisor in Brussels and participated in the subgroups of the Article 29 Working Party. She's now US-based, working for the DC-based think tank, the Future Privacy Forum, as a senior privacy counsel. And to my mind, Gabriela is also very much a natural-born teacher. And what all of us count on her for every day are very clear and timely analysis of the big policy developments and judgments in data protection law. She's an ability to break things down and zone in on the important new learnings. Finally then, Omer, Tene, whose moderator seat I've hijacked today. He has a day job as the Vice President and Chief Knowledge Officer of the International Association of Privacy Professionals, based in New Hampshire. Like all of the other panelists, Omer has very many strings to his bow, and aside from also being a senior fellow at the Future Privacy Forum, a co-founder of the Israeli Tech Policy Institute, and an affiliate scholar at the Stanford Center for Internet and Society, what I appreciate and associate him with is the publication of very insightful, pragmatic, and accessible papers on key questions in data protection of our time. Examples include Taming the Golem, which was on ethical algorithmic decision-making with really rich real-world examples, The Theory of Creepy, and his recent editing of the Introduction to the Cambridge Handbook of Consumer Privacy, to name just a few examples. So, with those introductions out of the way then, let's talk about the 3 topics that I've told the panelists I want to zone in on today. With just an hour, there are so many topics we could pick, but I decided we'd zone in on 3. International data transfers, topical; ad tech, also topical; and notice and consent, it never goes away. So Franziska, can I come to you first then on the subject of international data transfers, because you've certainly written on this issue in terms of your writings on Privacy Shield and your analysis of Schrems 1. We know that in the EU we start off with a prohibition on transfers of EU data out of the EEA, with the idea being that protections come to nothing if you can simply export the data to a jurisdiction with lower protections. But I hear all the time that the definition of transfer does not coincide with modern day internet technologies and cloud technology, that it harks back to an era of taking out the hard disk, putting it in your suitcase and flying to a third country with it. And then others say prohibition is the wrong starting point. What do you say to all of that? Do we have the right starting point in the EU? And if we do have the right starting point, are the legal mechanisms to facilitate transfers the correct mechanisms given the ongoing issues we're seeing?
Okay, thank you, Helen. Thank you also for the nice introduction. It's true, I'm a big I criticize the Privacy Shield, but I also see that this ban of let's say, data exports is maybe, at least for me, the only way how it works, at least at the moment, because if you imagine what happens if we turn it around and we just let the data float free to any country and then try to make the controls afterwards, I think this would be very difficult, and we already see that even if it might be a burden for a lot of data exporters and importers to have these kind of adequacy requirement and with all its lengthy procedures before, it is still feasible to do it in a way. As you can see at the recent Japan decision, I mean, it is I know, even if there are differences, it is still possible to reach a kind of, let's say, compromise on that. And if the ban is a starting point, I would even agree that it's a good thing, because if you leave, and we saw what happens if you leave industry too much space, if you turn it around and if you just leave it open, even now industry is not always complying with all these data transfer rules, so it might be really difficult to turn it around, and it might be maybe a bit disappointing to answer that, but I also had the experience that if we don't have these rules in place. Then industry is really using each way to transfer data, maybe in a not compliant way. And you see at the recent Japan decision, it's feasible. Countries can reach that kind of level of protection. And I hope that in future we might have different solutions, maybe shorter procedures, maybe technical procedures. This might be a way forward to have a certified software mechanism which allows maybe transfers much easier and much shorter than we have it now. I think this might be one solution to future transfers, but now we still have that compliant mechanism, which is, of course, due to our, let's say, tough fundamental rights guarantees. And in future, I hope there are some kind of technical solutions for that.
So you've written, Franziska, you've done an analysis of the Schrems One opinion and in particular the essence of the fundamental right that the CJU spoke about for the first time in that decision that it made. In terms of where current court cases may go, could you contemplate, for example, an effective complete ban on transfers to the US as a third country? Is that realistic? And in physical terms, how would you stop the data flows? How would that materialize?
Yeah, I mean, I think that it is a high burden on DPAs, and that the court, and I mean, you are involved in this, is giving a lot of power to the DPAs and says that DPAs have not even the right, but also the duty to control that and also to ban data transfers. I don't know whether this is the solution, but at least it gives the responsibility to a certain, let's say, authority who can control that. And I know that DPAs need maybe a bit more, let's say, human resources, maybe more technical people to control that. I don't know whether this is always the way forward, but at least it's one solution to the problem that banning data is the last possible way, I would say. And maybe there are other solutions of DPAs intervening in these kind of transfer forms, maybe some kind of well, let's say, requirements that are posed to data importers or exporters before banning the transfer. This should be the ultimate solution, of course, but I would still follow the approach of empowering the DPA to decide these kind of issues. I would be interested in how you see it, but as you are a DPA.
If only I wasn't moderating, I would love to answer that. But I'm going to move on to Neil. Sorry, Omer, you're trying to tell me to talk into the mic. It's hard to look at everyone and speak into the mic, but I'll try and do better. Neil, you clearly know a lot about the issue of international data transfers, and particularly as concerns the EU to the US. In fact, you acted as an expert on US law before the Irish High Court in terms of the reference case that the Irish DPC took. Undoubtedly, you've read the recent Advocate General opinion in that case. And of course, he has said that he saw nothing that led to a view that the SCCs themselves should be invalidated. But what he put emphasis on is that in the first instance, the importer and exporter have to be responsible for conducting an analysis effectively of the laws and practices of the third country to ensure there's nothing that contradicts the safeguards in the SCCs, and that the exporter should suspend if the exporter is on notice that they can't be complied with, and then of course failing that, as Franziska said, the data protection authorities must come in and suspend. Can you talk to us about how you think that would work in practice, the exporter and importer conducting that complex analysis of laws and practices that, in my experience of conducting that in respect to the US, includes looking at what the intelligence agencies are doing and a very complex array of laws? How will it work? So,
let me say at first that there actually is literally a hot seat, because we're sort of under these lights, and it is incredibly hot in here. That said, I think the question is a really interesting one. I have no idea how that would actually work in practice. I think it's as we saw as we've seen over the litigation over the past 4 or 5 years, it's very difficult for court systems to engage in an assessment of the adequacy of protections under contracts or under regulations of surveillance systems by domestic and foreign governments, and just trying to think about how a company that is importing or exporting, let's say even within a subsidiary relationship. One American social network does spring to mind, but of course, as the question suggests, this would apply to a full range of companies, from very small ones to very large ones. I don't know how a large company, let's say Google, to avoid the obvious example, would engage in an assessment of the adequacy of protections afforded to EU citizens under their fundamental rights of privacy and data protection against the NSA or against post-Brexit GCHQ, who have a possibly even shadier record of aggressive surveillance practices. As an Englishman, I can say this without sounding xenophobic, which is nice because given Brexit, there's so much xenophobia running in both of my countries right now. I think it's difficult for that to happen for a large company. But how would a small company or even a so Enterprise Rent-A-Car is headquartered in St. Louis, and they have kiosks at every major train station and airport in the world. How are they supposed to engage in an assessment of information practices? How is a smaller company supposed to? So I think. And this is what academics do well, criticize stupidity that is advanced by regulators and by companies. I just don't see any reasonable way that even a large company could engage in the kind of analysis that the Advocate General suggests, much less a small company. And that's even putting to one side the fact that there are going to be business incentives, even if they could engage in it. In a close case, a company is going to want to either in a transactional context or for internal operations within a subsidiary relationship are going to want to have the data. So there are pressures on them to find adequacy or to find protection. So I think that's really not a satisfying solution to the very real and very complicated problems that case does raise with respect to international data transfers.
So are you suggesting, Neil, that really the only solution then in terms of the EU starting point of a prohibition is the adequacy finding assessment and system as operated by the EU Commission, that they're really the only entity placed to conduct the necessary analysis? Is that what you're actually saying, that if the other mechanisms, the derogations, rely on individual companies in the first instance, that's not workable?
Well, no, I think the difficulty with this particular case is the derogation for standard contractual clauses. So I think that when you're not discussing the national security context, I think things can work very differently. But the problem with the SEC cases that has always struck me as peculiar is how can if you're in a situation where there is inadequate protection, we'll just sort of stipulate that, where there are surveillance practices in a foreign country, let's say it's Canada, right? Although I guess Canada might have adequacy, that's about. But so where there's insufficient security protections, I don't see how a contract between two private parties can opt you out of government surveillance. So I think if the concern is overweening government surveillance, there may be other protections. Maybe binding corporate rules could work in a way that the data is not exposed to surveillance agencies by it just not being there. But if the data is going to flow and the surveillance practices are themselves inadequate, I've always struggled to see how a private contract between two parties can somehow solve that fundamental rights issue.
Okay, would you agree with that, Omer?
Yeah, thanks, Helen. I sort of taking a step back here, I think looking at data protection laws in general, and specifically this issue, there's a lot of legal fiction. one legal fiction concerns this concept of adequacy in data transfers. Another is the notion of consent, which I know you want to talk about a little later. Paul Ohm, our good friend from Georgetown, showed us that the notion of de-identification or anonymization itself is a legal fiction because it doesn't work that way. Just in terms of the numbers, the computer science behind it. I think there is a legitimate need and requirement really from the European side for accountability of entities, companies, government departments who would like to export data outside the jurisdiction. Because once that's done, you basically have no hook for keeping them honest and keeping them accountable and enforcing against them. And we see that in other areas of the law. And I think there are different ways to try to solve it. Sometimes you require a local subsidiary and you require it to be capitalized and to accept jurisdiction for different purposes, not to sort of always claim that it's not subject to the local domestic law or forum. That's one way to address it. The U.S., takes a different approach, and in terms of U.S. law, basically it always applies globally. U.S. law has no boundaries, and if they want, they'll beat you with a stick that big that, you'll just recoil. And we've seen it in taxation, for example, where U.S. imposed FATCA, causing banks all over the world to run to report their U.S. persons' clients. So I think there are different laws to try to expand and assert jurisdiction. The adequacy framework, the assumption that some body, some entity will go out and assess, make a comprehensive assessment of the adequacy, whatever that even means, of the laws. And it's not just the laws, it's the entire legal, administrative, constitutional, procedural system of a foreign nation. In my mind, is far-fetched, and I think the result is that we talk about a hot seat, we see everyone sort of punting and trying to point fingers at someone else. So the commission, the courts, the regulators, the private parties, the companies, it seems that no one is enthused about this mission of trying to assess the adequacy of another country's laws, not least the U.S., which has such an incredibly sophisticated and nuanced and textured and, very difficult system with dozens of federal laws and hundreds of state laws and the Constitution and different systems playing together. Look, I was involved in the Israeli adequacy process. I worked with the Israeli government to try to achieve it. Israel is a country that's a sliver, of the complexity of the U.S. Do I think that the European Union got it right and actually managed to sort of dissect and see through the Israeli system in all its complexity? And it's, it's not just the system, constitution, law, administrative, it's also tradition, legal tradition. For example, we have in Israel a very forceful attorney general, not just by the law, also by tradition. They, they prosecute prime ministers and presidents.
So did they get it right? Did the commission get it right?
Did they get it right?
With Israel.
Well, I was representing the government of Israel and we got the adequacy, so yes. But I think questions can be asked and actually are asked now when they need to recertify.
Okay, Gabriela, it's getting worse the more we talk about it. Have you got the solution?
Yes, I will solve it. I will solve the issue of international data transfers. I certainly wish to do that, right? And perhaps I will just put on the hat of the dreamer and the, forever optimist. But I think we can also look a bit, take like 3 steps back and look at this entire international transfer situation from a diplomacy perspective. So let's think of a privacy diplomacy, if you want. And I believe that the solution is not in our legal technicality and discussing about standard contractual clauses and specific legal institutions. I think a lot can be achieved if governments talk to each other, understand each other, and try to find a diplomatic solution, for example, because at least when we're talking about Europe and the United States, obviously the biggest problem is the national security aspect of it, right? And I'm afraid that data protection law cannot solve that. I think the solution for that should be at a sort of a higher intergovernmental level. So there you go. This could be one solution. And then for just quick reaction to the question of how could controllers, how could companies just ban a transfer themselves if they find a problem. Now I take back my steps and I go at ground level. I go on the ground and I'm thinking of the supposedly almighty DPO. This is why the data protection officer was created in the GDPR with such a strong independent position. The DPO should be protected by all national laws here against getting fired, actually, for doing their job in terms of analysis on substance of data protection issues. So I can imagine, again, with the eternal optimist hat, that we have strong DPOs that can actually do this kind of analysis and put it forward to the companies, and even if the companies fight back, the DPOs could fight back because they're supposed to be independent. Now, I'm not sure if this will translate into reality soon, but that was the idea behind creating that special position for the DPO.
Okay, Gabriela, while you're on a dreaming roll, let me stick with you and move on to ad tech and see if we can make any inroads there. It's an area the subject of huge complaints. My office has at least 5 or 6 investigations open relevant to the ad tech sector. Huge concerns that our freedoms are being eroded by the constant profiling and tracking. And perhaps in response to being outed by the media, the New York Times privacy series, and now the investigations by regulators, we're seeing some mobilization in the sector. We've seen some announcements from Google in relation to ending third-party cookies on Chrome, removing contextual categories from their real-time bidding system, and so on. But always when there's an announcement that seems to be a step forward in privacy terms in ad tech, there are counter-arguments that the big platforms with their huge first-party relationships will never lose out, and they're really going to just kill off the third parties, that it's anti-competitive. Equally, we hear about the concern about small independent publishers going out of business if something radical happens. If you were in charge of the world for a day and given the complex ecosystem there, how would you unravel and fix this?
I'm at a loss of words because with the forever optimist that I am, I really don't have a solution for solving this. But what I can say, though, is that I've seen in recent years so much pressure also in the US on the ad tech ecosystem, the current one. And the latest example is the effort that is going on in California. We already have the California Consumer Privacy Act that just started to be enforced this January, and that certainly had as a target untangling the ad tech ecosystem because its main protections are against selling of the data and sharing of personal information. And now we are seeing a new ballot initiative in California that wants to be even stronger and put even more pressure on this entire ecosystem. So I think that even the changes we are seeing now being announced by search engine providers are a result of the fact that there is much more pressure from the public, much more pressure from legislators, and I think this is the only way how we can find a solution to this, just having a lot of attention, paying a lot of attention to this phenomenon and putting pressure on untangling that entire ecosystem.
Okay, very interesting. Omer, you published a paper with Jules Polonetsky in 2012. It was called Advancing Transparency and Individual Control in Online Behavioral Advertising. And back then in 2012, you suggested that the ultimate solution is that policymakers need to come to deep value judgments in a nuanced way that reflect both the need for privacy protection but also the benefits of economic efficiency and free access to information services. So you were very much about balancing that right we all have to read free newspapers online and so on. Do you think, given that you published that a year before the Edward Snowden disclosures, that you would still have published it a year later? Have we realized that it's not just about the pair of red shoes following us around the internet, that ad tech has a much more serious underbelly to it potentially?
Yeah, so I have to plead ignorance. I don't remember what I wrote there, and I think in generally I would say that the statute of limitations for any article I write is about 10 months. So I think you said 2012, that's far outside of, long expired. But, to the point and the points that Gabriela raised about the ad tech space, I think it's problematic to build a business model and, an entire industry or parts of an industry on a model that is disliked continuously in survey after survey by consumers. In that, the only sort of way to get it to continue working is to hide the facts from individuals, plus to do it in a way that provides some of the large platforms the ability to turn the switch on it at any point. So I think, ad tech has been on the wrong side of history for several years now, certainly with respect to regulation that already is in place or is still coming down the pipe here in Europe with the privacy reg in the US with the second California initiative and maybe US federal privacy law, and also with the power of platforms to just take unilateral actions. And you mentioned the fact that Google announced Chrome will phase out third-party cookies. That will inflict tremendous pain on the ad tech industry without much recourse to, you can't change that through lobbying because Google doesn't reach decisions by democratic vote.
Do you think it's a good thing?
Say again?
Do you think it's a good thing that they're ending third-party cookies on Chrome?
I think it's a complicated balance. It has competitive implications and it has privacy implications, and it won't kill tracking and, sort of reinforce privacy forever. There already are other ways to track individuals. Maybe there will be more verified identities and logged-in tracking. Maybe there will be fingerprinting of the different types. So I don't know if at the end of the day it will be better or worse for what? For whom? For the economy, for consumers. But I do think that the ad tech model that's currently in place is being phased out.
Franziska and Neil, I want to come back over to you on ad tech. I don't know whether either of you or both of you have come across the recent paper from Ken Bamberger et al. At Berkeley. And it was a bit of a bombshell paper from my point of view. It's called "Can You Pay for Privacy? Consumer Expectations and Behavior of Free and paid apps. And as you know, they studied almost 6,000 Android mobile apps. They looked at the paid and free version of each. And they found that in at least half of the cases of the paid apps, exactly the same tracking, taking, sharing, and selling of our personal data was happening. So this idea that we've all had, that it's the free services that we have to put up with those being fueled by behavioral advertising, now we see that the paid apps aren't necessarily behaving any differently. What does this paper mean?
Well, I would say it just shows the reality, and I'm really, really in favor, and I'm, let's say, working towards this, to have a kind of external control on software developments, and maybe develop a kind of traffic light system for algorithms or apps or something like that. So we always look at legal solutions, but we should have maybe a broader view on that, and involve more economists or more computer scientists in finding a solution for, let's say, a labeling system for apps that consumers really know what kind of apps they produce, because you can't read all these kind of dialogues which you just click and agree. This has also to do with the consent debate you just maybe tackle afterwards, but I would really say it's not only a legal task, and we control cars, for instance. We have a system for these kind of, let's say, dangerous things, and if we notice that apps and other software developments are also going in the wrong direction and misuse the current system, then we should do something against it and develop systems which allow the consumer to decide by themselves whether it's a good or bad app maybe to be used, yeah, it just shows that reality we have.
And actually, that's one of the things Ken Bamberger highlights in his paper, the tools they developed to do that analysis. He's suggesting they should be available to the public. One of the things that paper says to me, Neil, is that really it's about privacy by design. If we really had privacy by design, those paid apps wouldn't be behaving in the way that they are. How is that being taught in the US, and do you know anything about whether it's being taught in the EU? Does it need to be taught at second level now, at secondary school or high school level, as well as at third level? What's there in terms of scholarship around privacy by design? It's fundamental, isn't it?
Well, I think it is, but I think what Ken's study shows, and I've known Ken a long time. We practiced law together in DC at the same firm in the early 2000s. I'm reminded of what The Guardian's Carol Cadwalader said when she was up here on stage last night, which is that we have a mess with respect to, and I hate the term ad tech. I think surveillance-based ads is a much better term for what is actually going on. And thank you. And from the big picture, we have built if we want to talk about ecosystems, a surveillance ecosystem of things that people read, purely so that advertising companies can deliver more efficient ads. And I think that is evil. I think what we need to do, Carol said, is regulate the shit out of them, direct quote. And I think that's right. I think without regulatory incentives, without requirements, privacy by design is going to remain the empty promise that it has been for 20 years. I think unless there are actual requirements, incentives, there are some competitive incentives, but regulatory incentives, there are certain things you cannot do. Then I think it's going to be very difficult to do that. So I want to answer your question about education. There have been developments to teach ethics in engineering. But again, as long as the business incentives that face technology companies are exploit as much data as you can that you can get away with, rush to get to the IPO, cash out, buy your Teslas and your house in Silicon Valley, I think it's very, very difficult for as Gabriela said, for well-meaning DPOs on the ground to do their jobs. It's difficult for very well-meaning DPAs sitting in Dublin and other places to gain traction, because in the absence of requirements to do this, it's very, very hard.
Can I? So I think there are ways to improve privacy in organizations and privacy by design, and certainly educating privacy-savvy workforce, even before dismantling, global capitalism. At the IAPP, that's part of our mission to define, promote, and improve the privacy and data protection profession worldwide. And we've done some research. My colleague, Caitlin Fennessy, our Director of Research, surveyed DPAs in Europe. She got responses from 17 or 18 of the DPAs, actually looking at how many organizations complied with the GDPR requirement to register a DPO. And she found that in 17 or 18 countries, more than 300,000 organizations already registered DPOs, and extrapolating from that to the 27 or 28 for now, for a couple of weeks, EU member states, that comes to more than 500,000 organizations that already have a DPO in place. Who are these people, and how will they be educated to know what is personally identifiable information or personal data, what is privacy by design, what is the identification, and how to make privacy better? I think that's a big challenge, and at the IAPP we'd like to help catalyze that and improve that. And we're doing it through different ways. One thing we did a couple of months ago is survey US law schools to start with, to see what privacy programs they have. So which schools have a formal privacy program, a certificate or a degree, maybe an LLM in privacy, which schools offer privacy courses at all, and which schools don't. And we came out with a report on that. We're going to greatly improve and expand this report to also look at computer science schools and B schools, and do it not just in the US but also globally, to hopefully motivate schools to try to train this workforce, which is already registered, so existing on the ground, and should be up to the test.
Okay, that's very interesting. Gabriela?
Quick, two points I want to make. First of all, I think a big part of the solution to this discussion are privacy engineers. And I see, for example, Bettina Berendt here in the room. I think privacy engineering should play a much bigger part in our data protection governance discussions. And directly connected to that, in the past year, I've been collaborating with the research group coordinated by Norman Sade, Professor Norman Sade at Carnegie Mellon University. And they are doing some incredible work there at Carnegie Mellon. They also have a master program for privacy engineering, specialized course, and I think this is certainly part of the solution. Then the second point I want to make about privacy by design, fortunately, now we have Article 25 of the GDPR. That's privacy by design, at least wherever the GDPR applies, so where the GDPR touches, is not a policy goal anymore. It's a legal obligation. Now we need to find, its content, its substance, and there's research on that. I've also published something in EDPL 2 years ago on that. But it's a legal obligation right now, and that's a great thing.
But, yeah, I agree, and I also have to add that we need to control this legal obligation, and I don't like to put more burden on DPAs, but maybe we need to develop a kind of control unit for these kind of things, and a technical control unit, and we need to label this afterwards so that it gets transparent what is good or bad for privacy. And this is something we don't have, but so we need more computer scientists to control these kind of things, otherwise it will never work. We will never have privacy by design if it's not controlled and enforced afterwards.
I think that's a good point you raise about what's good and what's bad, because that's what we're hearing from a lot of controllers 20 months into the GDPR. We hear a lot about what's wrong and constant critiques, but not enough examples of this looks good. And so companies in some cases don't know what they're trying to attain. So I think that is a very good point. Let's move on for the last 20 minutes then to the real old chestnut in terms of intractable data protection problems. And it's linked, of course, to everything we have talked about, and it's the issue of notice and consent. We've had endless study after study, including a new one that I read this week from Aarhus, Denmark, University in Denmark, about the number of hours it would take any of us to read the privacy notices that are presented to us for the most popular apps and websites we all typically use. We have comment after comment stating the obvious that none of us read these notices. It's a design that seems to put all the pressure on the individual in terms of if we consent, will tough on us then. And even if we leave aside consent, notice is required regardless of what lawful basis an organisation relies on. So even if they say we're doing this in our legitimate interests, they still have to give notice to users. What is the solution to this? We're having the same conversation year in, year out, pre-GDPR, post-GDPR. In fact, I think, Omer, you've suggested at one stage it got worse post-GDPR because of companies fearing they were being fined. What's the solution, Omer?
You're asking me?
Yeah.
Well, I'll preface this by saying that obviously I don't know, but I'll still use a couple of minutes to talk about it. I think consent is just an integral part of privacy, and there's no real way to decouple them, because a privacy invasion really does happen only in the absence of consent. If there's real consent, there's no privacy invasion by definition, as I see it. And this means that you just can't pry them apart. We've seen some legislative language. So in the US now, there's a big push towards federal privacy law. I think well, obviously, we are much closer to it than it's ever been in the past, and I think it will happen within the short future. Some of the drafts we've seen try to omit the concept of consent or take it out of different places in the law. And in my mind, it always yields a framework that is overly rigid and both over-inclusive and under-inclusive. Because if you want to prohibit certain practices, even the most egregious data practices, if they are done with real, honest, informed consent, they should be allowed with the most sensitive data, healthcare information, facial recognition.
Can I interrupt you and ask you to forget about consent for a moment? Let's just talk about transparency, because it's required regardless of whether consent is the legal basis. What's the solution to the transparency conundrum? How can we really see what's happening?
Transparency is good, and the better it can be designed and delivered, I think the happier consumers will be. Some of the operating system manufacturers for phones, I think, have nice toggle keys, and those are pretty intuitive. Of course, the more nuanced the subject is, the more such toggle switches you will have, and then quickly, it becomes more complicated. But I think it's all a matter of trying to design it and present it in a way that's intuitive and not trying to sneak stuff in.
Is that the solution, Neil? More toggle switches?
Clearly, I think the solution to all of our global privacy problems can be solved with just better privacy policies and more radio. But no, I mean that's bollocks. I think notice and choice have been an utter and complete failure. Moreover, notice and choice have been the dangerous fiction whereby we've created this enormous surveillance system out of the tremendous promise of the internet in the 1990s. Notice and choice and transparency have been the dangerous tools whereby large platforms have cornered the advertising market, destroyed the business model of journalism, and led to things like Trump and Brexit. Notice and choice have been the source of all this, and the idea that if we could just somehow perfect notice and choice, things would be better is a terrible idea. I mean, I think we need to do better than this, and I think constantly coming back to notions like consent deludes us from the fact that there are certain business practices we just need to stop. That we need, like, what Facebook did with Cambridge Analytica was evil, and to the detriment of virtually everybody living in Western society, right? These are the stakes here. It's not whether we can have better or more nuanced business models or just a little bit more magical innovation. I think what we are discussing in the context of these issues is the very fabric of what post-industrial democracy is going to look like.
So then we're agreed the current system isn't good. Flowing on from what Omer was saying about toggles and different ways of communicating information more intuitively, I don't know if you've seen the Sidewalk Labs work that they're doing on Smart City in Canada, and they've produced a series of icons and symbols that will convey whether the sensitive personal data, and context in a non-language way. What do you think are solutions like that what we should be pursuing?
I think solutions like that can be helpful. They may even be necessary to empower consumers, but they are not sufficient. I think the most important thing, we have academics in the hot seat. Academics are supposed to generate ideas. And leave those ideas to practitioners to try and implement. The most important thing we need to produce out of this is a way to achieve trust in the digital environment. That's the most important thing. Much more important than consent. People don't want to read privacy policies. People don't want to assess risk and assess their options. They want to be able to live their lives and trust that they are not being manipulated or being exploited or being abused or being harmed. And I think the solution to that is to have baseline requirements. And Woody Hartzog, who's in the article on the aisle here, and I have written a series of articles calling for 4 principles that should guide us in this area. The 4 trust principles are honesty. Companies should be honest with their, and that's where I think things like better notifications can help. But better notifications are not by themselves sufficient. There should be discretion, which is limits on data sharing. There should be protection, affirmative obligations to protect consumers and citizens from the harm that third parties can engage in. And most fundamentally, there should be loyalty, that consumers and citizens should be able to use digital technologies with an assurance that they are not being exploited, that they are not being betrayed, that they are not being manipulated by these companies. And I think ultimately, we talked about the privacy profession in the last set of questions, and I didn't get to weigh in on that. It would be a tragedy for our community if all we did was become a set of mandarins who can be brought in so we can be paid to justify existing bad data practices. I think what needs to happen, and I think the GDPR does this, but the GDPR doesn't apply, despite its best efforts, all over the world yet. In the United States, the GDPR most of the time does not apply. And what we need to have are substantive rules that prohibit evil data practices. And I think we should not be able to consent to evil. We should just take, as a regulatory matter, we should just take evil practices off the table.
Franziska, how do we get transparency about the evil?
Yeah, I think we really need to pay attention that we don't throw these kind of terms, transparency around and everything is okay afterwards, because we always require, as lawyers, some form of, let's say, description, or this should be transparent, but we don't know exactly what this means. And I think there are so many research projects not led by lawyers, so we should have a look on them as well, which, for instance, crawl these consent dialogues with the help of AI techniques, and then give a kind of advice with whether it is good or bad to you for privacy, in terms of privacy, to use these kind of software developments or apps. So these kind of forms should be also supported, because we always throw around with these terms and then invent some legal requirements, but they need to be transposed into practical terms, and this is something we should maybe support even more. I know it's on the way, but it could be done much more and much more interdisciplinary than we already are doing it, I think, all of us, and not throwing just around these kind of terms.
Great. Omer, did you want to come back in on something Neil said? I'm going to bring Gabriela in. I didn't know if you wanted to respond to something Neil said, but we can go to Gabriela. Great. We'll go to Gabriela first.
I have 3 reactions, points to make. So, first reaction is for Neil's points. You mentioned the 4 trust principles, which I think they are great, and I also think that all of them can be traced back to obligations in the GDPR and some provisions of the GDPR, and I'm very happy to have a conversation about that after the panel. That's the first point. Then the second point...
We have a panel on that tomorrow where Helen will also be participating about a US GDPR at 2:15 in the big hall across the street. So please come to that.
So actually I wrote a post last year on 10 reasons why the GDPR is not a notice and choice type of law. And I have there 10 arguments that try to explain that to some degree of success. The second point on consent, you said it earlier to pass the microphone, Helen, and you said, let's forget a bit about consent. And my first participation to CPDP was, I do believe, 2013, about 7 years ago. And I was a PhD researcher back then. That was my first conference in English ever, because I was researching in Romania. And the title of my paper was Forgetting About Consent, why the focus should be on suitable safeguards in data protection law. So that was, I think that consent certainly has a role to play in privacy and data protection law, but data protection law, even under the former directive, and all the more so now under the GDPR, is much more about suitable safeguards, about principles like data minimization, like fairness, and about accountability, and especially under the GDPR with accountability, with having risk assessments done, data protection officers, and having controllers being proactive about that. It's not that much about consent ultimately. This is what I believe. I believed back then, I also believe it now. And then on the point of notices, I think transparency is one of those things that should be a red line, in the sense that we should always have transparency in a privacy or data protection law. People should be aware of what is happening with their personal information. And then we should find solutions to make it workable in real life. And you are absolutely right, Franziska, that computer scientists are doing a tremendous job at looking at these issues. And I will refer to a project of the Carnegie Mellon University Research Group that has been working on a machine-readable privacy policy tool that would scan a privacy policy and then, would tell you exactly what you are looking for and you want to know. So, for example, that's one of the existing research projects right now. And then icons, I think, could be a solution for sure. And the GDPR also looks at icons as possible solutions.
Omer, what did you want to add
so,
to that?
Being an Israeli, I love fiery rhetoric and commend I commend Neil on the use of bullocks and sort of portraying notice and choice as the thing that destroyed Western democracy and civilization. I don't know if it's helpful, though, for the conversation.
So can I just say, I've not called for the abolition of global capitalism, which Omer accused me of.
Yeah.
And I've not said that notice and choice destroyed Western civilization. But I will cop to notice and choice having a significant effect on damaging Western democracy. Yes, I said that.
I also, you know, wouldn't necessarily portray data protection professionals as mandarins who sort of are called in to bless evil corporate data practices. I think most of them are conscientious and try to do their jobs, and to their job at least is to try to improve corporate data practices. I do think, though, that, like it or not, consent is not going to be extracted from the privacy framework. If you look at the bills currently on the Hill, even it is a bipartisan bill, but it comes from the House, which is dominated by Democrats and by California Democrats specifically. It is a consent-focused privacy law. It has an opt-in component and an opt-out component. And if you think of just particular situations, do you want to allow an individual to opt in to sharing their genetic data in order to identify their relatives? Do you want to allow people to opt out or maybe opt into secondary uses of healthcare information for research purposes? Do you want to allow people to decide if their specific geolocation data will be used to help them select a different path in a smart city, smart transportation? These things inevitably will be presented to individuals to decide, and I think in that case, the best we can do is to try to help them make informed decisions.
Absolutely. Consent isn't going to go away, and of course, with those examples, nor should it. I think I was just trying to focus in on what information do you give the individual to make the consent real. We've just a few minutes of the panel left. We've been warned it'll get very noisy at 1 o'clock once lunch starts. Are there any burning questions in the audience that you'd like to put to our academic panelists?
For the panelists, not for the moderator.
Okay. My name is Andrea Lisievich and I'm from Volvo Cars. I'm actually a friend of Gabriela's for quite a while now. And the discussion about international transfers brought back a memory of actually a discussion that I was having with her some while ago. Because my opinion is actually closer to Neil's in the sense that any contract between two private entities will never solve the fact that other states can ask for information and they can change the safeguards that they have in place, and they can not give too much damn about what the parties actually want to do. That's not under debate now, but I wanted to ask the panelists what they think of the following situation. So the controller is not allowed to shift the burden of risk assessment to either the data subject or to the processor. However, the regulatory environment, the EU in this case, is leaving all of the burden to the controller. And although the goal of ensuring data protection is the European Union's, it's all shifted down to the controller, who has nobody else to shift it to or to even divide it. And the EU has a somewhat arrogant position saying, we're not giving you the limits. We're not saying what you can do or what you can't do. You choose, you decide, you assess the risks, and you are the one liable for it. And also, to that point, if I can add, in Article 49, one of the situations of transfers that are allowed is for important reasons of public interest, but that needs to be underlined in an EU member state law. So you're not allowed to use that for situations from outside of the EU.
Okay, thank you very much for that very articulate comment. I think it really picks up on the discussion we had earlier with Neil about how can what the Advocate General has outlined in terms of the role of the exporter really be implemented in practice. There was one more question that we might squeeze in.
Hi, thanks. Rebecca Bali-Barco, recovering academic, now privacy engineer at Google. Thank you for mentioning privacy engineering as a profession and mentioning the Carnegie Mellon program. Last I heard, they have less than a dozen graduates every year. And I was hoping you could speak to whether you think that's appropriate, whether any of the players, regulators, industry, academia, have a role in promoting or continuing that profession.
Do you want to ask your last question, and then we'll see if we can wrap the two
I'll
up
just be
together.
very quick. Laura Lindqvist, Professor Laws and Business. I just wanted to go back to data transfers and adequacy. So we've seen it takes the European Commission a long, long time to produce these decisions. As academics, do you see any formula or sort of scoring sheet that could be developed to just make that process a little bit quicker so we could see those decisions being sped up?
Franziska, could we speed up adequacy? Could the Commission speed it up?
Yeah, I understand that business likes to speed up the process and that companies like to do or like to have these kind of shorter processes. I would say if you like to have a thorough fundamental rights assessment, you need some time. And time is just one, let's say, point of the assessment. So there might be in future short procedures which are possible, maybe by using some, let's say, technical solutions, or by using these kind of, maybe we have the privacy shield, which is a sector-specific solution, so you might have more of these sector-specific solutions which go a bit quicker than these lengthy adequacy procedure. But I'm really against these kind of, well, we need a short-term solution for businesses, because if we do it, we see that it doesn't work. Yeah, they just circumvent it. And yeah, I'm really against it. And just one word to the first question of the controller in the international transfer thing. I mean, the controller can go to the DPA and ask. Yeah, it's not forbidden. So he can inform himself. It's of course a big responsibility, but he also makes a good business with it. So he has possibilities to be informed. And yeah, it's a burden, but there are persons to be addressed.
Just to the engineering comment, that's exactly what we're trying to do, to achieve, to expand those programs. And even law schools, we saw just a really small proportion of them actually embrace privacy. It's like IP law maybe 20 years ago now, despite there being so many employment opportunities and such an acute shortage of talent. So yes, for law schools, yes, for computer science schools. We're working with Lori, she's actually on our board, and Annie Anton at Georgia Tech, and our friends at NIST to make that better.
Okay, we're just out of time and going to get the final bell. So thank you very much to all of our panelists. Thanks to all of you for coming along and participating.